Hello, and welcome to SCG Global Spin. Your host today is Henry Bubel. Henry has over 42 years of tax experience and has been at Patterson Belknap for more than 40 years, where he was a partner for a decade and now operates in an of-counsel capacity. He has an in-depth knowledge of the income taxation of both corporations and partnerships, as well as estate, gift, and trust taxation. In addition to his work at Patterson Belknap, Henry serves as a director of both closely held businesses and charitable foundations and is trustee of client-related trusts. He was previously the board chair for SCG Legal. Joining Henry today is Jenny Longman. Jenny is counsel in Patterson Belknap's tax department, where she has advised clients on numerous matters, including corporate and partnership tax issues, corporate reorganizations, business acquisitions and dispositions, cross-border payment issues, foreign and domestic trust matters, state and local tax planning issues, and tax controversy matters. We also have Tiffany Tam. Tiffany is an associate in Patterson Belknap's tax department, where she advises on a broad range of partnership, corporate, tax controversy, and tax-exempt matters. Prior to joining the firm, Tiffany practiced tax law at an international tax firm based in New York.
All right. Well, welcome to an SCG webinar. Many of you know me. I'm Henry Bubel. I'm here today with my colleagues Tiffany Tam and Jenny Longman to talk about some of the cross-border tax issues that come up as a result of COVID quarantining by people across the border from the territory in which they're normally living and working. We've done a previous webinar like this. I did one with Matt Carlson of the Bluetown Jones firm, talking about the state and local aspects within the United States. And today we're going to talk more about the cross-international border tax issues that come up. Here in the United States, we have two particular areas of focus with cross-border displacements. We have Canadians, many of whom are used to spending the winter in Canada and then, in Miami or other places in Florida, and then going back north for the summer, many of whom didn't get to do that this year, and many of whom have apartments or houses or other places that they could simply stay in quarantine. And of course, we have Latin Americans who have come up and stayed because the COVID conditions in Latin America are generally worse than here in the US. I break these into two different groups because Canada is among the various countries with which we have tax treaties that address or change the results. Whereas most of the Latin American countries are countries with which the U.S. does not have tax treaties that might ameliorate some of the problems that arise. I realize that this situation also arises in some other countries in the world which share close borders with others. I'm certainly familiar with situations in say, Switzerland, where people typically come in from their homes across the French border and to work in Geneva, or come in from Austria or other places to work in the eastern part of Switzerland. And there'd be similar issues, I think, in those jurisdictions, even though they tax on residency, not on citizenship. Let me start with a hypothetical example of the kind of thing we worry about. I'll start with the example of the Canadian who perhaps regularly spends time in Florida during the winter, but this winter stayed a little longer, right? And perhaps is still there, and perhaps will just stay there throughout the year until this COVID mess is over. If you've been in Florida in the wintertime, you'll notice how many Canadian license plates there are on the roads. And that's a pretty good indication that many of the people have driven to Florida and don't really feel comfortable driving back that far home just yet. Okay, so with that, I think we're gonna talk about again problems that come up for individuals who are displaced, but also tax issues that can come up for the businesses for which they work while they're being displaced. So we're going to try to cover all of that. So with that introduction, let me turn it over to Jenny Longman, who's going to talk first about the displaced individual and the relatively limited guidance that we have thus far from the IRS. Jenny?
Thanks. So we thought it would be helpful to first just provide a high-level introduction to U.S. tax residency, because that's what drives these issues. Most people know that a U.S. citizen is taxable by the U.S. on worldwide income, and U.S. tax residents are also taxed on their worldwide income. Green card holders are per se U.S. tax residents. And for those who are neither a U.S. citizen nor a green card holder, the relevant test is really a function of day count, so days of presence spent in the United States. The U.S. test is called the substantial presence test. And if a person spends 31 days in a given calendar year, and the sum of the days spent in that calendar year, as well as the preceding 2 calendar years with a specific weight for each date in those years, equals or exceeds 183 days, then that individual will be a tax resident for the calendar year. So it's essentially a look back calculation where you have to look not only at the year being tested, but you also need to look at the prior year and the year before that. So because of the nature of this formula, that can get us, into trouble when it comes to the COVID guidance, which we'll speak about in a few minutes. But what we find for many of our clients who try not to be U.S. tax residents, they seek to spend really no more than 120 days, let's say, on average, in the United States each year. And if they can remain present for 120 days or less on an ongoing basis, then they won't reach that threshold that forms the relevant number of days for the U.S. substantial presence test. If somebody is over on the day count for a given year, there is some relief under our non-COVID, our regular rules. One exception is showing a closer connection to a foreign country. And to do so, that person needs to file a form and describe contacts with that other country. And that way, even if they're above the 183 days on this look back period test, they can avoid being treated as a U.S. tax resident for the given calendar year. Sometimes a tax treaty can also be of assistance. There are treaty tiebreaker rules for residency, and those can also be of help to an individual who finds themselves stuck in the United States. There are a couple of exceptions to counting days of presence under our normal rules. One deals with the status of that individual in the U.S. for immigration purposes. And a common example that you hear about there is a student visa. So students can be present in the United States without triggering tax residency. It only works for a certain number of years, but that's a common exception to day counting under the substantial presence test. And another important exception is the medical exception. And that's what underlies the COVID-19 guidance that we'll get to. So under that exception, if an individual is present in the United States and then has some sort of medical issue that prevents that person from leaving, then the days when that person would have otherwise have already left the United States are not counted for purposes of the substantial presence test. So it's important to note that that exception will not be of any assistance for an individual who comes to the United States for a medical procedure for some sort of underlying condition. But it really is of help to someone who falls ill in the United States and then can't leave, or has an accident, or, a heart attack or something like that. So with that, I think we'll move to the COVID-19 guidance, and we will also address some of the shortcomings in that guidance. So Tiffany is going to go over the IRS guidance on the expanded medical exception as it applies to COVID-19.
Thanks, Jenny. So the IRS has kind of recognized that COVID can present a challenge for many people who are in the US and maybe couldn't get out because of any number of reasons. And so they've expanded the normal medical exception to cover any number of COVID-related emergency travel disruptions. So here, non-residents are able to avoid counting days that they are in the US for purposes of the tax residency test that Jenny described, but they don't actually have to contract COVID-19 to take advantage of this exception. Any number of things such as canceled flights or hotel reservations, quarantine orders, border closures, or simply feeling unsafe to travel, given the dangers of being in crowded public places or social distancing guidelines. All of these are sufficient reason to take advantage of this COVID-19 emergency travel disruption exception to counting days. The non-resident still has to have intended to leave the US, but for these COVID disruptions, they had their plans disrupted. The number of days that they can exclude from counting for their residency substantial presence test is 60 consecutive days, and they can elect for that 60-day block to start anytime between February and April of this year. So basically, the last 60-day block would have already expired by June 1st. So if you haven't already elected, it's unfortunately too late to do this. So in addition to kind of setting forth this substantive COVID-19 emergency travel disruption exception, the IRS has issued some guidance on how to claim these various, the medical condition exception and also the COVID-19 exception. And they've set forth kind of 3 different types of proof that you have to show. And all of these are affirmatively disclosed by a non-resident on a particular form that needs to be filed with the IRS. You can think of it as having, again, 3 levels of proof. I think the highest is the normal medical exception. There, in order to claim that, you actually need a formal doctor's written statement saying that you had this condition that prevented you from leaving the US and that it wasn't a pre-existing condition. So it really arose after you had arrived into the country. And that's the highest level. Kind of this second level is a new lowered standard of proof that the IRS has provided some guidance on, kind of recognizing that COVID-19 has really placed a strain on the healthcare system, and it's not always feasible to get a doctor's formal statement for your tax return. And so they've allowed non-residents to claim 30 consecutive days under that normal medical exception, but they don't need a doctor's note. All they need is some kind of other documentary evidence to substantiate that they had some kind of medical condition. So things like a receipt of a healthcare purchase or notes from notes from some kind of email or some confirmation from a healthcare provider or evidence of a canceled travel reservation. Things of that nature would be sufficient proof to claim that 30 days. And then finally, the third type of proof is for the COVID-19 exception in particular. And there, again, it's kind of self-certifying. You don't need a doctor's note or anything of that nature. You can just have travel receipts or reservation changes, even evidence from the U.S. Customs and Border Protection Agency has a database called the I-94 that you can check online that keeps a record of all of your a non-resident's entries into the country. So that would be another form of proof of claiming that COVID exception to counting days in the U.S.
Tiffany, let me interrupt you for a moment. When you mentioned the 60-day period that could be elected for the April-May period, I believe you said that if you hadn't made the election, it was too late. I think maybe you meant to say it was too late to plan, because most of the proofs that you explained would go on a tax return, right?
Yeah.
So
I just meant the period has lapsed. the 60-day period that
Or
you
in
would
other words,
claim.
if you stayed beyond that, you're on days that count.
Exactly.
Okay, thank you.
And maybe it makes sense to go back just to think a little bit about, well, now we have the advantage of knowing what happened in this country, since June, when this guidance came out. I think it came out in May, and everyone was thinking, okay, well, this is helpful. Maybe the government's going to extend it, because right now things are still looking pretty sketchy. Airlines were canceling flights. It was not an easy task to leave the country in May, June. And, now looking back over the summer, I can't say I've heard of all too many people who traveled anywhere, certainly by plane. And, we were almost tax lawyers. We were all wondering, okay, is the IRS going to extend this further? They have not. So we're left with this 60-day period that, we think in many cases will fall short of really providing the relief necessary under certain fact patterns. And one other issue I wanted to just raise quickly was that this guidance only applies to individuals who were not tax resident in 2019. And days present in the United States are also very relevant for determining a residency end date in a taxable year, where you might have what we call a short year. So, like, let's suppose somebody really planned to be out of the United States by, say, March of 1 year, but was a tax resident before then. There are special rules that mark when that person's really out. So these COVID rules don't help a person in that situation. So someone who was planning to, say, leave March 1st, but then got stuck here, say, through the summer, will not be able to identify a 60-day period and say, oh, you know what, just pretend I was out of the country by my original plan date of March 1st. And the residency end date can be of critical importance to someone who is trying to be a non-resident alien, who might have an important income tax event occurring at some point in the year. And often they want to make sure they're not a U.S. tax resident on that critical date. So we could see this, being a problem for tax residents, from 2019 and earlier, who were trying to make plans to leave the United States in 2020, but were not able to. So I know there have been comments out there to the IRS to try to extend some of this guidance so that it would apply to individuals who were already tax resident and had issues trying to leave. But to our knowledge, it has not been expanded to cover individuals in that situation.
Thank you. Let me also ask you to clarify that if you're beyond the 60-day forgiveness period, if you will, in 2020, that when it comes to 2021, do the forgiven days count when doing the look back calculation? Is that clear under the guidance that was given? Or do I have to count those 60 days when I'm testing not for 2020, but for 2021?
I believe since they key off of the medical exception, and the medical exception is tied to day count principles within the regulations that govern the substantial presence test, that the COVID exception days should not count, regardless of what year, you're testing. That may be clarified in future guidance, but I believe that is the intent, so that, the days spent, just because they prevent you from having an issue in 2020, they shouldn't mess up your tax situation in 2021 or 2022 either. Yeah.
Okay. Thank you. Yeah, and as I mentioned very early in the program, when we talk about people physically present in the United States and how that might impact their businesses, Tiffany's going to go through and explain that it really does matter in many cases whether the person here is here from a business located in a treaty country or a non-treaty country, because the ramifications can be quite different. Tiffany?
So in addition to issuing some guidance and relief for non-resident individuals, the IRS has also issued some guidance to help out foreigners who might be deemed to be engaged in a U.S. trade or business, which can lead to U.S. tax burden. And so kind of backing up a little bit, we thought it would be helpful to give an overview of the U.S. trade or business rules and kind of how those work. And so generally, foreigners are not subject to U.S. tax unless they have certain types of passive type income, or if they're deemed to be engaged in a U.S. trade or business and they earn income that's effectively connected with that business, or ECI, effectively connected income. And so if you are deemed to be ETB or engaged in a trade or business, then you are subject to U.S. tax at graduated rates. It is on a net basis, so you can take into account expenses. Generally, foreign business as well as a foreign individual can be ETB or engaged in a U.S. trade or business. There's no kind of bright line rules for a foreign business, but the IRS will take a look at kind of all of the facts and circumstances and make a specific determination of whether that foreign business's activities in the U.S. have risen to the level of being a U.S. trade or business. And they consider whether there's considerable, continuous, and regular activities. And so there is a quantitative element there in terms of how much time is spent by that business or agents of that business. A non-resident individual can also be engaged in a U.S. trade or business if they perform personal services in the U.S. There are some limited exceptions to that rule. They're not terribly useful, but one of them is for employees. If they're providing services in the U.S., they are not deemed to be engaged in a U.S. trade or business if their employer is a non-resident, they spend no more than 90 days in the U.S., and their compensation doesn't exceed $3,000. This is a pretty low amount. This rule, this special exception, was passed decades ago, hasn't been adjusted for inflation, so it's not terribly useful in 2020.
Any such individual needs to find a new job.
But as Henry alluded to, there are kind of comparable but different treaty rules, one of which is for dependent personal services. And if a non-resident is a tax resident of a country that has an income tax treaty with the U.S., oftentimes there's a special exception for them where they won't be deemed to be engaged in a U.S. trade or business, and they won't be subject to U.S. tax if they spend no more than 183 days in the U.S. Their employer is also a non-U.S. employer, and if their salary is not deducted by that employer's permanent establishment. And that PE concept is kind of comparable to a U.S. trade or business, but for treaty countries in particular. And so again, there is a day count rule there that can come into play. And Jenny's going to talk a little bit about the COVID-related relief that the IRS has provided.
Yes, so the COVID guidance on this point doesn't give us a whole lot to talk about. It piggybacks off of the guidance for the substantial presence test. But interestingly, the U.S. trade or business guidance was delivered in the form of a couple of Q&As on the IRS website. So we're talking like, I don't know, maybe we have 4 paragraphs of prose on this subject. But, in a nutshell, the same 60-day period is to be identified as just not counting for purposes of analyzing the business activity in the U.S. And that applies in the context of being deemed to be engaged in a U.S. trade or business for an individual or for a foreign business entity, or for purposes of determining whether there's a permanent establishment in the United States connected to the business at issue. But again, it's limited to 60 days. And, those 60 days are only a short span of the days that may or may not be posing a problem for a given business or an individual. So imagine an individual who came into the U.S. maybe when things were starting to look a little better, maybe June, July or something, and then gets stuck in a hot spot and really just isn't in a position to leave. Well, that's not one of the periods that is eligible for this special 60-day exception. So, again, we do think the IRS guidance is likely to fall short in a number of scenarios.
Let's talk about the practicality for a minute of the IRS taking a look at non-resident aliens who are here and working in some capacity, perhaps on their iPad or their laptop, and working as remotely as you and I do in our law practice, and never getting paid from a U.S. source, so there's nobody claiming a deduction in the U.S. and perhaps the compensation is being directly deposited into their accounts abroad. Okay, it will be, as a practical matter, difficult for the IRS to pick up on this. But we have all sorts of exchange of information provisions with other countries. I don't think we want to do all of our tax planning assuming that none of the facts will ever be known. And I think that's the important point to keep in mind here, that we do have some real pitfalls that can happen. They won't happen automatically. They won't happen regularly, but they're pitfalls nevertheless if you're trying to advise a client. But I noticed by the clock that we're actually out of time. So I think it's better for me to invite people, okay, who have some specific questions to perhaps send them to me, and I'll discuss them with Tiffany and Jenny, okay? And I'd also like to hear from those of you, particularly abroad, about similar issues that are happening in your jurisdictions, particularly with respect to Americans who may be stuck where they are in your part of the world, because we hear a little bit less about that than the situation we talked about this morning. So thank you for your time and listening. And I missed many of you at our September meeting because there was no September meeting. But I hope there will be one in the future. Okay, take care. Stay safe. Thanks for listening. Okay. Thank you, Jenny. Thank you, Tiffany.
And that concludes our recording. Thank you for joining us today. You can find this and many other episodes at scgglobalspin.com.